Chair, you do have a quorum.
Representative Fox moves to adopt the minutes from the May 13th meeting. There being no objection, the motion prevails by unanimous consent. Today, the committee will be hearing testimony from attorney Erick Kaardal, who will be speaking to the concerns relating to elections in Michigan. Welcome, Mr. Kaardal, and thank you for coming. There's a mic if you, thank you.
President Pro Tem and representatives, I'm honored to be here. It's a privilege to speak to the committee. I offer friendship. What I have is experience in basically advocating for ordinary people and businesses against the government for 30 years. I went to Harvard, University of Chicago Law School, and I fell into this practice. People said, well, why would you want to do that? Well, I was helping people, and I made a career out of it, so I'm quite good at it. At the 2020, I saw an opportunity to be helpful again and become focused on election issues in 3 swing states, Wisconsin, Michigan, and Pennsylvania. So in those states, I've been helping in different ways, observing, investigating, making legal efforts to reform laws, and then also litigation. I counted up how many victories I've had in the election integrity subject area. I call successes, and it's probably like 75. A lot of those in Minnesota where I'm situated. So in order to help you understand your role as a state legislature, I developed this talk, and it's intended to be nonpartisan and just sort of useful for you to rethink maybe how you'd approach these issues. So let's begin with let's see if it works here, the elections clause. Okay, it's not working. Let's see. Okay.
One moment, our IT will be right. We'll be right with you.
So it was working. Did I not hit something? Oh, yeah, use that clicker. Okay, got it. All right, thank you. So on the elections clause, you're all familiar with the times, place, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations except as the place of choosing senators. Now, everyone reads that, and they're like in the state legislature, and think, oh, well, we have the authority to do that. And that's true, but there's this deeper question in the context. Why did the framers do that? And we should be concerned about why would the framers pull out this one function and say we want the state legislature involved? Well, I would propose to you that what they wanted was, and the title of my talk is, a fair campaign competition. That with respect to federal elections, they wanted the state legislature to prescribe the rules before the election began. You know, let's look at the National Basketball Association, right? You have a rules committee, and why you have a rules committee in that professional sports league is to set the rules before the election begins. And so true, the state legislature would look at adopting the rules, laws that regulating federal elections before the election, but importantly, the rules that you set before the election, the laws regulating federal elections, they then are binding on the state executives. So we're talking about the Secretary of State, the governor, so forth, the clerks. They're all bound. They can't make up stuff during the campaign. Just like during the NBA season, the refs can't make up new rules. They have to go to the rules committee just like the executives should. It's a very important background point as we look at other things. And so here I cover some of those points, but the U.S. Supreme Court in the recent decision, Moore v. Harper, that was a case out of North Carolina, indicated that the state legislatures have a particular federal authority to regulate federal elections in their state. But it also said that the state legislature is bound by the state constitutional limitations. So what would that be? You're all aware, it'd be the governor's veto, right? But just because the governor has the veto power doesn't mean the state executive branch can disregard state law regulating federal elections. Does that make sense? So there's some authority that the governor has, that is to veto your bills. You can override them, but that's the limited interpretation of the power of the state executive branch regarding setting the laws prior to the election. And so we have to follow through on these different aspects of who is supposed to be regulating the elections. And the U.S. courts have a doctrine that actually applies to this. Now, I'm trying to convince the U.S. Supreme Court in a case called Boss v. the State of Illinois that they should apply the rules of fair competition to elections. So in the rules of fair competition, when this government, Congress, or the legislature sets the rules of fair competition, and executive officials do something contrary to law, they create an unlawful competition, unlawfully structured competition, which means that participants, like candidates, should have standing to sue. They're being injured when state executives don't follow the state enacted laws regulating federal elections. Imagine an NBA game. The rules are set regarding like dribbling, and then a referee favors one team by saying, oh, you've dribbled when actually they haven't dribbled, but I've changed the rule in the game so you have actually dribbled. That's a problem. We can't have the state election officials change the law during a competition because it's unfair to the candidates who are running for federal office. It's very important to understand these fundamentals to understand exactly what the rules are. So to understand that, I made a chart. So remember, the Elections Clause is an exception. So typically, under the Supremacy Clause, Article 6 of the U.S. Constitution, Congress is supreme, the president has the veto power, the state legislature isn't supreme because the Congress is supreme, but the governor can veto your laws, and of course, state election officials are non-supreme. But under the Elections Clause, Congress has supreme power, but so does the state legislature. You have a supreme power. You're regulating federal elections, and that's indicated in the Election Clause that I read to you. But both Congress and the governor, with respect to election laws, can have their bills vetoed. So you don't want to say they don't have any power, because they can actually affect the election laws before the election by vetoing your respective bills. But again, the state election officials, the Secretary of State and so forth, are non-supreme. Under the Electors Clause, the state legislature even has more power with respect to legislating regarding the presidential electors process. So it's really important as a background to understand when you're talking about election laws regulating federal elections, the state legislature has this unique, important role, and it needs to be emphasized to get it right. The principal concern and why I'm here and why I think that I was motivated to get involved in election integrity issues in Wisconsin, Michigan, and Pennsylvania is that billionaires on both sides have been looking at election processes and figuring out how to get a high return on investment. And so they're looking at ways to work with the government, sometimes legal, sometimes unlawful, to change laws, change processes. And an easy target, is the changing the policies at the Secretary of State's office or changing the policies at the clerk's office. And that's what they're doing. And they're pretty public about it. And so we have to watch what the billionaires and their nonprofits are doing. Are they properly influencing elections, or are they unduly influencing elections? And there's a lot of money involved, a ton of money, as you all know, and particularly in Michigan, a lot of out-of-state money coming in. So the paradigm case, and this is a bipartisan point, but I really love this case. It's Obama for America and the Democratic National Committee versus Ohio. The idea there was that military voters were getting extra time for in-person early voting as opposed to non-military voters. And the U.S. Court of Appeals for the Sixth Circuit, which covers Michigan, agreed that you can't target a group of voters for special treatment, and if you do, that's a violation of equal protection. So a lot of the things that we'll see that the billionaires are doing is targeting groups of voters through the voter registration system and through Get Out the Vote efforts, all government sponsored, that would help them win elections. So it's both left and right. Like, we want to work with the government to get our voters out to vote. And it was great that the Obama for America and the DNC brought this case, and it's a precedent that we want to see developed. So private funding of election administration, holy smokes. I was out of the gates pretty early on this one. We filed 8 lawsuits in 8 different states in 2020 to stop the private money for election administration funded by Center for Tech and Civic Life and Mr. Zuckerberg. And although none of those lawsuits came to fruition, there were technical problems and so forth. But the good news was in most of those states, I think 6 of the 8, before the lawsuits could be concluded, the state laws were adopted banning private funding of election administration in really important swing states. So when I talk about swing states, they're important, and Michigan's one of them. So the good news is Georgia, Arizona, and Pennsylvania, Governor Wolf, Tom Wolf, a Democrat in 2021, signed a law banning private funding of election administration. And then Wisconsin in April of 2024 passed a constitutional amendment banning private funding of election administration. So Michigan's the last swing state that allows private funding of election administration. And I think there's reasons why Georgia, Arizona, Pennsylvania, and Wisconsin did that, and why some Democrats like Governor Wolf in Pennsylvania are willing to sign on to it, because it's a bad look. Privately funding the clerk's office, it can come with strings attached. The documents I've seen in Michigan from 2020 and from Wisconsin in 2020 showed the Center for Tech and Civic Life had lots of strings attached. In fact, in Wisconsin, the absentee ballot drop boxes that were funded at the time were found to be illegal. So they were privately funded illegal absentee ballot drop boxes. Now I understand the decision was reversed by the Wisconsin Supreme Court, but at the time they were illegal. And so let's think about, is private funding of election administration something that Michigan needs or wants? In the deal in Pennsylvania, Governor Wolf got assurances that enough money would come from the government to fund election administration. So he was happy and signed on to, we don't need the private funding. Maybe that'd be a solution here in Michigan. The Electronic Registration Information Center, in 2020, there were, I think, 34 states in Erick, and due to our efforts and our friends, about, I think, 7 or 8 states have pulled out. Big states, too, like Florida, Texas, and Ohio. The swing states have not pulled out yet. Arizona, Georgia, Pennsylvania, Wisconsin, and Michigan are still in. And so the criticisms of Erick are real in the sense that all of our driver data, everyone's driver data in Michigan, is shared with Erick. And so it's shared exclusively with Erick. Other groups can't get that. Now, Erick is a Delaware nonprofit corporation. And so why do they get the driver data, and should they be getting the driver data? Now, in my view, that was answered by Congress in the Driver Privacy Protection Act. So it's a federal law that says that, driver data can't be shared unless it's one of these purposes. And the political purpose that Erick's using it for to registered voters isn't in the list of permissible purposes. So it's a violation of federal law, and there's a private cause of action there, and we're going to be pursuing that basically a person whose driver data is being shared in an unauthorized way can sue in federal court. And here you have all the people's data being shared with Erick in legally unauthorized way, so we would expect some litigation. Also, with respect to the Help America Vote Act, there's a provision that when, this is a federal law, when the Department of Motor Vehicles shares the driver data with the Secretary of State, here the Michigan Secretary of State, that the driver data is only supposed to be used to verify the voter registration application information that the driver provided to the Department of Motor Vehicles. So that's a real limitation. And then you have Erick taking the data and using it for other purposes. So it also exceeds the limitation on HAVA. But I think the worst part, the thing that should cause the most concern, is the decline to register information. So why Erick wants the driver data, I believe, mostly, is because it's impossible to find out who's declined to register at the Department of Motor Vehicles without this information being transferred to something like Erick. So remember, the person comes in, they decline to register. So they're not in the voter registration file, the qualified voter file. And so Erick wants the people who've declined to register so they know who those people are, so they can choose or not choose to attempt to get them to register. Now, the state of Michigan also agrees to send out government-funded and sponsored voter registration application postcards to the people that Erick indicates should receive them. And so there are lots of criticisms here. And I just point out that many states have pulled out. These are great states like Michigan, Texas, Ohio, Florida, and maybe the state of Michigan should look at how they're doing since they pulled out. The reports I've seen is they're doing very well without Erick, and it doesn't have the vulnerabilities. There is an email showing that Erick has transferred the information to other nonprofits. It's very hard to track the data, once it's gone out of government hands. Another program it's kind of like a sister program. It's like same methodology but different subject area. So remember, we're talking about driver data. Now we're switching to Civic All-In Democracy Challenge, which is called All-In. And basically, it's a Obama administration staffer, very bright professional, Valerie Jarrett, started a nonprofit to get universities and colleges and post-secondary schools to ramp up the student voter registration rates and student voting rates. And so many of your Michigan schools are participating, and I'm particularly concerned about the state universities, University of Michigan, Michigan State, Grand Valley, and so forth. And so how it works is that the university signs up, and they agree that they're going to set high voter registration rate goals and voter rate goals for students. So they're demographically targeting students. Now typically, remember I talked about fair competition? That the state legislature is supposed to prescribe the laws regulating federal elections, regulating the manner of federal elections. So they should be coming through you. The University of Michigan, Michigan State should be coming through you and say, hey, we want to increase the student voting rates. Can we get some money? But that's not how this came down. The Civic Nation All-In Democracy Challenge is working in all 50 states to get the state universities to sign up. So they've avoided the ordinary process of going to the state legislature and saying, hey, we got a problem, young people aren't voting. Now, when I talk to young people, because I know I work in these areas, and other people, they're upset because state resources are being used to target students at universities to vote. And why aren't people who are high school graduates not targeted? I mean, high school voters are important too, high school graduate voters. Why are we focused in Michigan, these resources, on just the students? About what, third of people get post-secondary degrees? So what about the other 2/3? The typical attitude is, well, you're gonna forgive their loans, my loans don't get forgiven. You focus on them voting, not me. I mean, that's the kind of response I've gotten, is that it's just really odd that the state universities are approaching it this way. So then what's wrong with this legally? Well, let's start with the FERPA. I'll start at the bottom there. Family Educational Rights and Privacy Act violations. The way, part of the program is that the student data is shared with National Student Clearinghouse, and from National Student Clearinghouse, it goes to Tufts University, which has a nonprofit called NSOLVE, National Student Voting Learning Education Center or something like that. And then it gets transferred to two for-profit companies, either Catalyst or L2. So this is the student data going through all these things. And the job of Catalyst and L2 is to merge the voting data with the student data. So if for some reason they don't want to do it over at the Tufts University or at National Student Clearinghouse, so then they merge the data. So all of a sudden you have the student data, all their information with their voting registration, voting information, voting history. And then the NSOLVE then reports back to the National Student Clearinghouse and the universities the voting registration rates and the voting rates, and then that becomes the part of the plan for the university to increase the voter registration rates and voting rates of the university students or community college students. And so what they've done over the last 5 or 6 election cycles is increase the student voter registration rates and student voting rates from 30, 40% to 70, 80%. It's really a successful government program in a sense, but government resources are being used for demographically targeted group, something I would say that like the Obama case would prohibit. Remember Obama said you can't target military voters? Well, why can you target student voters? I mean, it's got to be fair competition for everybody, even this voter registration aspect. So one of the things, initially was, oh, we're going to have to litigate this and we're going to have to work really hard But the FERPA violations are pretty clear. Now, unlike the Driver Privacy Protection Act I described before, the federal law doesn't give a private cause of action. So a student can't sue under the federal law in federal court, but the Secretary of Education can stop it because Secretary of Education has enforcement authority regarding the Family Educational Rights and Privacy Act. So, Michigan should ask the Secretary of Education, Linda McMahon, could you please stop this? It's not what we want. We don't want student data used for political purposes. Now, maybe the comeback from Civic Nation All in Democracy Challenge could be there's a different way to do it, but this sort of exclusivity towards this one nonprofit and having access to this information or access to the privileged and confidential information, just isn't fair competition. And so we have to, kind of unveil things. And so, we want university students to vote, but we want high school graduates to vote too. And so it's like, okay, where is this coming from? Can we have a conversation about the use of government resources in the election area, which is fair to everyone, a fair competition? The response of the high school graduates on that, by the way, was, I don't have any dignity? I mean, why doesn't the government treat me why are you targeting university students? I'm not a university student. What, am I heir? And it's really a concern. In this election area, it's really important to treat people equally and with dignity because we need to keep people on board with our common project. UOCAVA, Uniform Overseas Citizens Absentee Voting Act, that's what we found, and not necessarily Michigan, because the data isn't available. It's tough to get data. Transparency is really important in order to get to the point with respect to election integrity. But we found that Secretaries of State are not verifying UOCAVA voter registration application information as required by law. UOCAVA is Uniform Overseas Citizens Absentee Voting Act. So the federal postcards come in, and they say, the federal postcard says, put your driver's license down or put your social security number. And if you don't do that, then you can provide alternative information. And our view is that until you provide some information confirming your identity, your vote shouldn't be counted. We litigated this issue in Pennsylvania, and it basically came down like this, is that initially, the argument of the Department of State was, we don't have to match the driver's license number and the social security number last four. We don't have to do it, but we are verifying it. And it was the hardest thing to, why would they be arguing they're not required to match the information against the database? Because they have the driver's license numbers, of course, and they have the social security numbers. And that was, but yet they're saying that they're doing it. So then before the 2024 election, there were daily absentee ballot reports in Pennsylvania, and the absentee ballot reports were coming out, and we saw with respect to the typical voters, that is the non-UOCAVA voters, the non-overseas voters, that they were processing the absentee ballots, and there were like 10,000 absentee ballots in a pending category. And that meant the Secretary of State had found a mismatch of 10,000 people, and the counties were following up to get alternative identification information like they're supposed to. But with respect to the overseas voters, it was zero. So they're doing no matching on the driver's license information and social security information of overseas voters. And 2/3 of these are non-military voters, 1/3 military. And so then we went into court, the Commonwealth Court, a 7-judge panel in Pittsburgh, and one of the questions to the opposing side was, okay, if I just wrote down a name on a postcard without a driver's license number and without a social security number, would that ever be followed up on? And ultimately, would the vote be counted? And they said, yes, the vote would be counted and it wouldn't be followed up on because they're not doing the mismatching, so the county wasn't getting the notice. They had to follow up for alternative information. This is a big gap in the system, and we need to really pay attention to this. And it looks like we need a legislative fix. The Commonwealth Court said that the verification of the identification information under UOCAVA was not required. And so we're considering a follow-up litigation on that. But it's very disturbing when people can just put in a name and cast a ballot. You need some verification of identity in order to have some integrity to that part of the system. Now, here's a topic that's a little more Michigan specific, and that is municipal ordinances requiring landlords to provide voter information to tenants. Now, remember All in Campus Democracy Challenge? They were working with university campuses to develop plans to increase student voting. So in the plans that, like the University of Michigan, Michigan State, East Michigan, and so forth, they would say, go to your municipalities and adopt ordinances requiring landlords to provide voter registration information to tenants. And then the universities would dutifully carry that out. And they succeeded in East Lansing, Michigan State, and Ypsilanti, Eastern Michigan, with respect to those ordinances. Now, we had caught this in St. Paul and Minneapolis, and in Madison, there was a separate group which identified the issues there previously. And so we litigated the issues in St. Paul, Minneapolis, East Lansing, Ypsilanti, and we won those cases on the notion of First Amendment compelled speech. So if the government can communicate directly to the tenants, hey, here's your voter registration application, register to vote, then the government needs to do it directly. You can't use tenants to do the government's job in that part. And that was the U.S. District Court judge in Minnesota who went to the merits on the issue, basically said that, look, I mean, this is a First Amendment compelled speech issue because the government can mail the voter registration applications to the tenants. We don't need the landlords to deliver them. Now, on malfunctioning voting machines, in a sense, I haven't said anything, any platitudes about myself, but I did avoid a lot of the issues regarding the voting machines because my clients simply didn't have enough resources. It's really complicated, the voting machine issue. However, when the machine doesn't work, okay, we can handle those issues. And so we found a few cases where the machine hasn't worked for various reasons. Leelanau County in Michigan, you may have heard, they had a problem with when they were doing the testing of the machine, they left the votes in, and the votes actually caused the election results to change, and then before certification, it was corrected. So those kind of mistakes can happen, but the biggest mistake we've seen was in Pennsylvania, where they're still using, in 3 counties, particularly a big county, Philadelphia County, they're still using the touch screens for voting. So when you hit the touch screen, you get out a piece of paper which has a pictograph and a barcode, and the tabulator only counts the barcode. So you're supposed to look at it and say, oh, okay, the receipt, the pictograph, I voted, this is the way I voted, it's fine, but it can be inconsistent with the barcode, as happened in a early 2024 election, and that was, the pictograph was coming out incorrectly in 2 of the 3 counties, Cumberland and Northampton County, and it was showing you voted for the opposite person. So people were being frustrated and they were hitting the button saying, I want to vote the other way so my pictograph looks correct, and they eventually shut the polls down, the machines weren't working. The company admitted a programming error, and then the clerk eventually resigned in Northampton County. And so then we did HAVA litigation, because under the Help America Vote Act, the Help America Vote Act requires each state to have state administrative procedures in order to enforce HAVA, and HAVA does regulate machines. And one of the requirements is having a verifiable, auditable, paper trail, basically. And we argued that this was like one and you're done. These machines are not working well. They're vulnerable to human programming error. They failed, and we need to have something better than a barcode to look at to determine whether who someone's voted for. And we argue that in the Commonwealth Court. It has not made they have not made their decision yet in Pennsylvania, that court. But the defense of the Assistant Attorney General's office included, we can teach people how to read barcodes. And so my co-counsel's response to Elizabeth Nielsen was that, well, require extraordinary training. But the point is that it's possible that it could be verifiable, someone who was trained in reading barcodes. But we want a paper trail in a swing state like so important as Pennsylvania that an ordinary person could verify the vote totals, and that would require the paper ballots like used in Michigan. And so these are the kind of the concerns that we have. Now, in that case, we hope the U.S. Department of Justice gets involved in bringing a HAVA claim to shut down these touch screens that are being used with the barcodes, and they are used in several states across the country, including Arkansas. Okay, absentee ballot drop locations. This is a big issue with respect to equitable distribution. And I know that Michigan has addressed this in some way with respect to a minimum number of absentee ballot drop boxes in certain areas. But you're particularly vulnerable to what we saw in the 2020 election on the private funding because you haven't banned it. So you have a minimum, but the scholarship shows that absentee ballot drop boxes work. It increases the percentage of voting by a fraction of 1%, like per mile. And so you could see private money coming into Michigan funding absentee ballot drop boxes and putting them in areas where, basically the billionaires want them. And so we really don't want billionaires gaming Michigan that way. They have so many resources, and they can go to a 501c3 and make an agreement with the city or with the county and say, oh, we're going to put all these drop boxes in. So not against absentee ballot drop boxes, but we have to watch for, they have to be regulated, in my view, not just the minimum, but also the maximum, because it offers opportunities for gamesmanship. Michigan constitutional amendments regulating federal elections. So Michigan in 2018 and 2022 has had constitutional amendments regulating federal elections, 3 of them. And there's talk about a ranked choice voting constitutional amendment in 2026. And then it's really interesting, legally, pretty interesting that you have 2 ways to amend the state constitution. Article 12, Section 1, which goes to the state legislature. Article 12, Section 2, which doesn't. It's citizen petition and a referendum. And then you think about that and then, how did this happen that in 2018 and 2022 that we saw the constitutional amendments regulating federal elections go through the Article 12, Section 2 process? So there's no state legislative approval. So remember the Rules Committee analogy I had? Well, how are these rules, the state constitution, how are these rules being changed without state legislative involvement when the Constitution says, the election clause says, the state legislature prescribes the regulations of federal elections, time, place, and manner? So that's a really big thing. Now, there was an effort in federal court to move that issue forward. I represented 10 or so state legislators, and we tried to get into federal court as individual state legislators on this issue, saying, hey, the state legislature needs to be involved in these kind of decisions and legal acts regulating federal elections. We found out yesterday the U.S. Supreme Court denied the petition, but that's on a technical ground that there's no individual state legislator standing on that issue. Fortunately, the Michigan Supreme Court has held that individual state legislator standing exists, the Dodak case. So we'll continue pursuing that angle in state court. And why that's important is everyone needs to know the rules. And we think the rules were set by the framers, that state legislative approval is necessary for changes in state law regulating federal elections. And we want to hear the state of Michigan, the executive branch, articulate their reasons why they think it's okay to cut the state legislature out. So remember, the Michigan Constitution says the state legislature is the Senate and the House, and the federal constitutional election clause says the state legislature regulates federal elections. So how can you avoid the state legislature when the Michigan Constitution says the state legislature is the Senate and the House? So we'll figure that out. I think one might say, well, are you opposed to the people making the decision through citizen petition? No, Article 12, Section 2 remains. It just can't be used for election law. Remember, I started my discussion by saying, election law is different. The state legislature's powers over election law, federal election law, is supreme. So not supreme in other areas, but supreme in this area. And so you have as much power as Congress does. Congress can trump you by preempting your laws, but almost as much power as Congress does to regulate federal elections. Another concern, I don't have any particulars on this one, but just when organizations sue a friendly Secretary of State and they settle the case, that's not good because that's cutting the state legislatures out too. And then I'm not going to go to that slide yet, but a few other mentions. On election inspectors in Michigan, there's a great law that Michigan has that half the election inspectors have to be one party, half the other. And we need to see the parties step up and collaborate more with the clerks to ensure that happens, because I think the clerks will respond favorably to that, but we might need to restart that because it's a fabulous way to increase confidence in election results. Well, they're half Republican, half Democrat. How can you complain? It must have gone well. And that's important. On the vacant Senate seat, this is very disturbing that Midland, Michigan isn't represented by a state senator. Now, when I had a case in Minnesota this last cycle where the House vote came down 67-67, and I was hired because one of the winning candidates, a Democrat, wasn't living in the district that he ran in. He said he was going to move, but he didn't move. And I won that case. And the progressive or liberal judge in Ramsey County said it's axiomatic that an area, a state legislative district, needs to have a resident representing it to have a representative government. So in Midland, it's worse because you don't even have anyone representing it. There's like 160,000 people with no representation. It really casts doubt whether the state Senate is a representative body when you don't have that seat filled. And so that is a real priority because we want to make sure that Michigan government operates democratically. And this is dependent on elections being called when there are vacant seats. Michigan, on HAVA administrative complaints, this again, I mentioned that the federal law says that Help America Vote Act is enforced against state officials, state election officials, through state administrative complaint processes. And we found that the state of Michigan's process is not good. So in Pennsylvania, when you file your HAVA complaint against a state election official, an administrative law judge is appointed. You're allowed to collect and present your evidence, use subpoenas. There's a hearing, there's an adjudication. Then you appeal to the Pennsylvania Commonwealth Court. And you have 7 judges there making sure that your claim is a good one or a bad one. And that's the process. Here, the Michigan Bureau of Elections, it doesn't provide the same adjudicative process. So we need to move to something where it's more adjudicative. In other words, that the citizen comes in and says, hey, I have a complaint that HAVA is being violated, like a malfunctioning machine or maybe the data, the driver data being shared in violation of HAVA. And then you have to have an adjudication, by a lawyer, because these are technical issues, not by an appointed body like that. So that's a problem. I know that cleaning up the voting rules is an issue. Non-citizens is an issue. In Ohio, it's very simple. Department of Motor Vehicles shares the non-citizen data with the Secretary of State, and then they're deregistered. So remember, people get driver's licenses with green cards, so they know who the non-citizens are, and then those people are deregistered, they can't vote because they're non-citizens. That was the law in Minnesota. There's a bipartisan moment after the Coleman-Franken race years ago, and this law was passed saying, okay, we'll make sure these non-citizens we know about aren't registered to vote. But recently a blue trifecta repealed that law, which didn't make any sense to me because we want to make sure that non-citizens don't vote. Another concern for me is ineligible wards. And in Wisconsin, there's been quite a bit of litigation about this. But again, we're getting into people this is court adjudicated people. The judge says should not be registered to vote and should not be voting. And in Wisconsin, we had a huge problem with nursing home registered resident voting rates in urban cities of 100%. And nothing should be 100%. And so we investigated that, and we found that the dementia wards were being voted. And then we also found that a lot of them were under these court orders saying, you're incapacitated, you can't vote. You can't register to vote. Those documents then would be sent by the court to the Wisconsin Election Commission, and the Wisconsin Election Commission would not record them. And so then we sent letters to the registrars in probate, the 73, who send the documents from the courthouse to the Wisconsin Election Commission, and 13 of them cooperated. And we told them, based on the Wisconsin Election Commission data, how many people in their county were listed as not eligible to vote because of an incompetency order. And they couldn't believe how few had been reported. The underreporting rate in the Wisconsin Election Commission in the 13 counties that cooperated, some big ones like Kenosha County and Brown County, was 90% to 100%. So in some counties where they had hundreds of people who should have been deregistered, none of them have been deregistered at all, and a lot of them were still voting. And they're voting because they got automatically mailed ballots, and like in the nursing home, they're voting. We talked to the Marla Vista Nursing Home Activities Director during the 2020 campaign in Green Bay, Wisconsin, and she basically just said, well, I signed all those absentee ballot applications in the dementia ward because someone at City Hall told me to, and if they didn't know what to do, just vote party line. And so, to me, there's a combination there of elder abuse and election integrity issue, but it's something that I would really go to the bat for because we really need to treat our elderly people with dignity. So, in the end here, I want to say that my experience has been a privilege to work with on election issues in Michigan, Wisconsin, and Pennsylvania, and I've learned a lot. And what we really need to do is dialogue across the aisle, Democrats and Republicans, to find the path to fair election competition. And really, it's the billionaires that are nonprofits who are monopolizing the strategies through the state executive official policies, and we need to respond to that. But you just list them, like I did here. Maybe I mentioned 15 issues. You just list them, and you say, this is what the billionaires are doing, and they're on both sides now, so we can't say it's just one side. Here's what the billionaires are doing. We've got to prevent that because it causes an unlawfully structured election environment, and that's unfair. We need lawfully structured election campaigns set by laws passed by the state legislature and by Congress. So my final slide is kind of the bad news, and that is lawfare against critics of government elections. This has really got to stop because when the billionaires came into the process through the methods I said, the government then started using prosecutions, civil lawsuits, ethical complaints against the critics of the billionaires. And it's really, really crazy. I view the civil and criminal cases against presidential candidate Donald Trump as lawfare. The civil lawsuit and criminal prosecution against the Trump 2020 presidential electors in Michigan as lawfare, and the threats of more prosecution against critics of government elections. So where there is justifiable criticism of billionaires entering our systems through state executive policies and circumventing state legislative power to prescribe the laws regulating time, place, manner of elections, these people must be protected because they're criticizing a usurpation of legislative authority. They're criticizing usurpation of legislative authority to gain an advantage in our federal elections. And so I think it's got to stop. The concern I have is that the First Amendment is becoming less popular among these state executive branch officials, and they're using the lawfare to shut down their critics. And they should be criticized if they're succumbing to the influence of billionaires rather than coming to the state legislature and asking to change the election laws before the next election. So thank you very much for your patience. I know I spoke on a long time, but it's an important topic, and so I took the time. Thank you, President Pro Tem.
Thank you very much for your presentation today, Mr. Kaardal. It was very insightful and helpful, and drew a lot of attention to a lot of concerns, as you mentioned, here in Michigan, that this committee hopefully and the rest of the legislature can take into consideration. With that, we will take questions. I have one in particular. I actually have a couple, but you mentioned transparency. That is key and pivotal, and something that might be lacking here quite a bit in Michigan. Why couldn't you get the data in Michigan here?
Yeah, there's a lot of challenges with respect to getting data in Michigan, Wisconsin, and Pennsylvania, but I think there's sort of the normal resistance. I mean, like a continuing legal education class might be, FOIA in Michigan, and when you're not criticizing the government, it's easy to get the data, but when you're criticizing the government, it's difficult to get the data. And so it costs a lot of money to litigate FOIA issues in Michigan state courts, and so it's a challenging environment. My understanding is even in the legislature, it's difficult to get information from the state executive branch officials in the election subject area. And so this shows a little bit of this dysfunctionality I described. But I think the way to work your way out of it is to convince people that, look, we need to have fair election competitions. We got to stop, or let's say regulate the influence of billionaires in the election system. So in billionaires in the election system, there are so many things they can do that are legal. They don't have to do things that are illegal. And so when you look at them setting up these nonprofits to get exclusive access to data like Erick does, or I talked about the All-in-Campus Democracy Challenge program, that those are like set up so that they get exclusively government data, and then the legislature can't get data from the state executive branch. What's going on? I mean, why do these nonprofits have a privileged position to get data that no one else can get, and the legislature can't even get data from the executive branch regarding elections? I think on everything that is government funded should be available for the state legislature to review. I mean, there's a fancy phrase in the courtroom, in-camera review, so at least the state legislators should be able to review it. Maybe there could be a segregated room with a light, and you go in and, oh, here are the election clerk manuals, here's what they say, and then you leave, and you have to leave a copy or whatever. I don't think they're national security secrets, but maybe there's an argument for that. But I think that common sense says that Michigan people want fair election competitions. Transparency is part of that, but the transparency issue, it's hard because, it kind of goes both ways. Because my experience is if you're criticizing a Republican official or a Democratic official regarding something, it's hard to get the information. And so the election is a little different, I suppose. But anyway, that's my experience suing the government has been. You sue the Republicans and Democrats on these types of issues, and it's tough to get the information. By the way, because about half my clients have been liberal, half conservative, I don't get invited to many cocktail parties. And I can report to you I've not been invited to any in Lansing, so thank you.
Well, thank you. I think it's important to note, too, yeah, you're right. It is no secret that the legislature can't even get our hands on very basic, simple training materials. So that's disappointing, at the least. We will move on with questions. Representative Song.
Thank you, Madam Chair. Your presentation is based on the idea that ballot voter petition initiative drives are unconstitutional when it comes to election laws. Wouldn't that disenfranchise millions of voters in your argument, and which was a lawsuit that was tossed out by a federal judge?
Right, I mentioned that. Yeah, we're going to continue the lawsuit in state court. It was dismissed on individual state legislator standing, something the Michigan Supreme Court has recognized, but the U.S. Supreme Court hasn't recognized under the Elections Clause, but it has recognized it under the Constitutional Amendment Ratification Clause of Article 5. So the issue with respect to why we're going to continue to pursue the case in state court is that we need an answer on whether this process should be used. There's even an argument that the framers of the Michigan Constitution never intended Article 12, Section 2 to be used for federal election regulation. If I were writing it, I would have probably put expressly in there under Article 12, Section 2, I would have said, except for regulating federal elections, because we know the state legislature needs to be involved. So I think on the state constitutional interpretation argument, I think it's pretty clear that it was never intended by the framers of the Michigan Constitution that Article 12, Section 2 procedure would be used to enact constitutional amendments regulating federal elections. So I think the proponents of that process are wrong on the Michigan Constitution, wrong on the federal Constitution, and I think always the intent has been the state legislature being involved in some way.
But your argument has been tossed out by a federal judge. So can you acknowledge that your argument would disenfranchise millions of voters and that their voice doesn't count?
Oh, well, yeah, I think your point, the judge dismissed for lack of standing, never got to the merits. So you've misstated what happened in federal court. That's why we can still proceed in state court. With respect to the mistake that the proponents made in the 2018-2022 constitutional amendment is they violated the Michigan Constitution, because the Michigan Constitution incorporates the federal elections clause, and that procedure can't be used to regulate federal elections because the Michigan Constitution, the framers would have known that the election clauses exist because the framers in the election clause said the state legislatures need to participate in regulating federal elections. Now, the comeback would be the people are the state legislature. But as we know, the Michigan Constitution defines what the state legislature is. It doesn't say the state legislature is the people. It says the state legislature is the Senate and the House. So I think that's where things really run aground for Michigan executive officials defending this process, for example, for the 2026 ranked choice voting. But there is a question there, I agree, that is the remedy, if I'm correct on my legal theories, that all those people who voted for the state constitutional amendments in 2018 and 2022 are in a sense disenfranchised because they voted for it? But this happens all the time. I mean, there's all sorts of laws that get passed, appear to be passed, and then are invalidated. In fact, like the Michigan state legislature can pass in the same session 2 bills that say the opposite thing. And then there are rules on how to interpret those things. And so with respect to, is it possible that the Michigan voters in 2018 and 2022 voted on a constitutional amendment that was invalidly presented to them? Absolutely, it happened. And I don't know why the out-of-state money, there was a lot of out-of-state money coming in 2018 and 2022, why they didn't do the legal vetting that I've done. If they had done the legal vetting, they would have understood, no, we got to go Article 12, Section 1. Now, why that's wise is that the process should go through the state legislature because you guys have committee structures, you have your procedures on the floor, and you get better election laws that way. And I think that's why the framers said it. They wanted to have the federal election laws be considered and deliberated upon before they were passed. And so I guess that's it. So on the disenfranchisement question, yeah, it's really embarrassing that Michigan did this in 2018 and 2022 in violation of the Michigan and U.S. Constitution, but you got to live with it. I mean, the decisions are made. Maybe the court will say we're going to leave those and prevent it in the future, but that ranked choice voting was proposed in the state legislature. You guys had it. You rejected it. Now they're using Article 12, Section 2 to avoid you. And then you're looking at your election clause prerogatives. Hey, we're the rules committee. And the NBA, of course, what happens is if the referees were making up the rules in violation of the rules committee's rules, they'd get fired. But that's not an option. That's not how it works. We have the courts basically to enforce things. And so yeah, it's if you're going, I have an essay out there called "Strategic Litigation Against Government." I've done about 1,000 lawsuits against the government, 300 appeals, 2 wins at the U.S. Supreme Court. And one of the things is that you don't always win against the government in your first lawsuit. You might have to do a lawsuit and a lawsuit and a lawsuit because it's hard because the government gets to position itself in response to the complaint, and there might be things you don't know and you have to move around. So I would take what happened in the U.S. Supreme Court yesterday as a step in the process. In fact, the good news for everyone, I think, is that the Boss case petition in the U.S. Supreme Court was rescheduled. So in the Boss case, Congressman Boss from Illinois is saying, hey, I'm a member of Congress, I was a congressional candidate, the state has illegal procedures, state executive branch have illegal procedures affecting my race. I should have standing in federal court to sue. And so Michigan Fair Elections has filed a amicus curiae brief in that case, and literally how I started this talk is my amicus curiae brief trying to convince the U.S. Supreme Court that the state legislature and Congress establish the rules for the fair election competition, and when state executive officials deviate, like with the 2018 and 2022 state constitutional amendments, then there needs to be, the federal court needs to step in and address those issues to ensure that congressional candidates have a fair election competition. So we've got to stop state executive officials from creating unlawfully structured election campaign environments so that we have fair and lawful elections. And the federal courts have a role, but you're right, individual state legislator standing was denied, but 32 Pennsylvania state legislators, who I represent, are filing this week another petition to the U.S. Supreme Court on the same issue of independent state legislator standing. And we hope the U.S. Supreme Court says, okay, we denied that one, but this one is important. In that case, the Pennsylvania governor issued an edict requiring automatic voter registration when that wasn't authorized by law. And the Department of State altered the absentee ballot voting procedures when that wasn't authorized by law either. So can state executive branch officials during the heat of an election change the laws? Well, no, that's change the laws. That's like what state legislatures do. That's not what
Thank you,
state
Madam
executive
Chair.
branch officials do. Thank you.
Representative Wooden.
Thank you, Chair. Appreciate you coming in today and giving your testimony. Kind of building on the question on the constitutionality of the citizen initiative process, it's of your opinion, and you've argued quite eloquently that you can't avoid the legislature. Now, there are now 2 proposed constitutional amendments, citizen-initiated constitutional amendments, that have gotten ballot language approved by the Board of Canvassers that would enact a documented proof of citizenship law. Similarly, these are citizens' initiatives that they are going to collect signatures, try to get on the ballot for 2026, thereby avoiding the legislature. In your opinion, then, based on the suits that you've filed in previous similar instances, do you find these initiatives would be unconstitutional?
Yes, that's procedure is the forbidden fruit, that when you lose in the legislature, you can't use Article 12, Section 2, to amend the Constitution to regulate time, place, and manner of federal elections.
Thank you.
Representative Outman.
Thank you, Madam Chair, and thank you, sir, for being here. Thank you for your presentation, and thank you for your efforts. I'm surprised you haven't been disbarred. Number of your
Not yet.
number of your colleagues have, very undemocratic in my opinion, but nonetheless, I'm concerned about the money in Michigan politics, and you raised some very valid concerns regarding that. My question is, Michigan alone can't regulate the spending of our elections, can they?
Well, on the state elections, yeah.
The
but
state elections,
yeah,
okay.
yeah. And the ballot questions too. It's something that's often forgotten, but the ballot questions are important. And even on the ballot questions, not only private funding, but I've noticed in the swing states here, government funding on one side or the other of a ballot question. And so that should be looked at too. I mean, I'm sort of old school about this. I mean, why is the government weighing in on one side or the other of ballot questions? But then I really got into school district bond referenda, and holy smokes, the school districts gear up for those things and use government resources to get them passed. And so, it's something to watch, like the government spending money to get ballot questions passed. I mean, you're talking about, I remember the NGOs getting government funding and so forth, and the money coming back into politics. So there's a lot of money around these issues, and so it should be regulated, state ballot questions and state candidate elections.
Okay, I appreciate that. And the reason I ask is I'm currently working on a resolution that's being drafted right now, and basically it's teethless as far as I'm concerned. But what it does is it's urging Congress to for the ability for states to set spending limits within their elections. And so it's helpful to know that discrepancy between state and federal elections and what limits we have here in Michigan. But, you've raised many valid points, particularly with these citizen-led ballot initiatives where state money is just flooding these campaigns. I mean, it's absolutely insane. And it's really dictating the way we legislate, as a matter of fact, because you also raise this, they can't get something done legislatively, so they go around it and they fund these massive special interest campaigns. And then that dictates how we legislate. Then we scramble and we water something down, or we put something together for fear of a ballot initiative. And it's really, really undemocratic, in my opinion, un-Republican, and just not a good way to legislate for the people of Michigan. And so very, very concerned about that. I'm glad you brought that up, sir.
Yeah, I shouldn't assume knowledge here, but so I just want to mention that in the background of the BICRA, the federal financial campaign reforms, And what's happened is that a lot of the billionaires' money, they don't want to spend it if it's not 501c3. So the billionaires give the money to the 501c3s, and then they're able to voter registration and get out the vote, which in the people have been around a long time, like clerks and stuff, older clerks. Well, how did that happen? Well, it's because of the way that things were reformed. The IRS has taken no enforcement actions against 501c3s engaging in voter registration and get out the vote activities. I mean, nominally it has to be nonpartisan, but they know who they're dialing up, so so that's why they're doing it. And then the people running the 501c3s on both sides, left and right, are telling the donors this is the highest ROI for your investment working through the 501c3s to do the voter registration drives and the get out the vote because it's tax deductible. So that's where all this money is going through. And then the temptation is, for the 501c3s then, is to work with state executive branch officials to even get higher ROIs through better data. I mentioned student data, driver data, through altering the procedures or getting the government to send out the postcards, voter registration application postcards. So all these temptations are there, and these are all new, and they need to be regulated by the state and by Congress. I don't have the solutions on that. I'm just sort of focusing on the judiciary. That's my job. It's sort of a weird thing I've done for 30 years, just focusing on the judicial branch. But you folks can investigate, okay, it's all out there in the public domain. All this money is going through these 501c3s to do voter registration and get out to vote, but it's sort of unregulated. So like even, it's kind of crazy, but the 501c3s can sponsor other 501c3s. So you may not know, like if there's a single donor behind like 15 501c3s that are driving student voting on campuses. So it's not the disclosure you'd expect with respect to campaign finance and so forth. And so the 501c3s are kind of evading the campaign finance reporting system. And just to be very honest, the progressives have been at it for 5 or 6 election cycles, and now the conservatives have caught up. And now it's time to okay, do we want to keep going this way, or do we want to have people be regulated? Because we don't want billionaires fighting over these state executive policies and rules and regulations, manipulating elections. The people just want a fair election procedure. For example, the people just want the election to be kind of over with, like counting. Like, let's get it done and move on and back to our ordinary life, take down the lawn signs. But the 501c3s are a 24/7, 52-week-a-year, all the time sort of thing, grinding away at, pointed towards the presidential elections. And so that's what Michigan's in. You've got these 501c3s out there watching everything you do. And okay, how is that going to affect the presidential election? How is that going to affect this and that? So I don't have the legislative solutions on that, but there is a need for someone to do the investigation and figure out how to sort of regain fair election competitions. But I'll warn you, both left and right, that the billionaires are going to be against you, that the 501c3s are going to say, no, we don't want to go in that direction because they want to manipulate it. So one of the things the U.S. Supreme Court said in Moore v. Harper was, that was a case where the North Carolina state legislature lost. Basically, the U.S. Supreme Court said, no, state legislatures, you're still limited by state constitutional and federal constitutional limitations, which of course we accept. But they said that each state has to have a code of elections for federal elections because you can't leave the discretion to your state executive branch officials. So even the code needs to be reviewed to make sure that you're satisfied that the referees of the elections aren't making up the rules as you go along. Imagine, the NBA Rules Committee, it's very detailed. One example I use, maybe in the past you could say, well, the clerks count the votes. Well, now you have to say, the clerks count each vote once.
Yeah. Well, sir, I think we got to move on, but I just want to say I totally agree with you. We have to get the money out of our elections. We particularly have to get the dark money out of our elections. And I just appreciate your efforts in that, so thank you.
Thank you. We've got time for 2 more questions. Representative Fox.
Thank you, Madam Chair, and thank you, Mr. Kaardal. Appreciate your being here. I guess, I'm just being reminded again of the importance of remembering we're a republic and not a democracy, through this discussion, and especially when we think about ballot initiatives. But I am wondering too what your response is. How much of this comes back to civil rights when you start talking fairness? We had the mention of the disenfranchised. Aren't we all being kind of disenfranchised by these billionaires and by these people who are trying to control things?
Yeah, civil rights, I mean, that's a really interesting, I'm a lawyer that sues the government, so I'm aware of civil rights. But a lot of the more important cases are just violations of the law. So you don't always run to civil rights because there are other principles at work. And so, yeah, we all need to be treated with dignity. I mentioned like high school graduates, their votes are should be just as important to the Michigan government as university and college students. But I think it goes a little bit deeper than civil rights. It's about executive officials exceeding their authority and understanding that hurts all of us. And so really, it's like when you enact the law, in order for our system to work, the expectation has to be that the state executive branch officials follow it. And when they take this turn, we have the discretion not to follow it, and only the courts can make us do it, it's broken. And so then in Michigan, the way we're going is that all we have left are the courts. And if the courts are going to be required to basically navigate and adjudicate every dispute between executive officials violating the state laws you've enacted, well, they're going to have to be really good. But if they're not good, I mean, it's a disaster. I think the prophet Amos said in chapter 5 that, hey, you go out there and fight your government, try to improve your culture, but if the courts go wrong, then it's okay to stay home and pray. So it's very difficult when you're in this situation, and I have a front row seat because I get to see the government arguments defending the conduct. And so it's really, when you go to court, you say, well, look, I mean, they're not following the law. What do you do if the court doesn't make the executive official follow the law? I mean, what, are you going to pass the law again? I mean, I've joked in the past, maybe we should have a constitutional convention, reenact the Constitution. Would that matter? No, of course it wouldn't matter, because we already have the Constitution. And so it's hard. Now, I have to tell you, quite frankly, that I have a difficult time, and I think Representative Wood's question is a good example, of ever disagreeing with a lawsuit against the government. Because the court is exercising its judicial muscles to ensure that the government officials are following the law. And it's good for the court. So when you see these cases from the left, civil rights or otherwise, it's a good thing. And then the courts have to make a decision one way or the other, and I might disagree in the end with the decision. But seeing the filing of the lawsuit is a good thing. So I would encourage the state legislature to consider private causes of action. So like Wisconsin has a beautiful law, 5.06. It's one of the reasons I chose Wisconsin to litigate post-2020. And 506 says that if a citizen witnesses an election official violating state law, they can file an administrative complaint. What a beautiful thing. And if the citizens then file those complaints, then they're adjudicated. Maybe the citizen saw it wrongly, maybe the citizen's wrong about the law, but it get it going. So when you hear the lawyers coming in saying, hey, we should have a private cause of action, that's a good thing. Now, when they ask for attorney fees, they might be self-interested. But when they're not asking for attorney's fees, then it's a good thing. So the Help America Vote Act has that private cause of action. The Driver Privacy Protection Act has that private cause of action. But in Michigan, we don't have a procedure where we can sue election officials for violating state election law.
So we've got one last question, Representative Colzar.
Thank you, Madam Chair. Please correct me if I'm wrong, sir, but one theme I noticed throughout your presentation is that you seem to oppose any concerted effort to increase voter registration. You made an argument about college campuses. You made an argument about landlords providing info to tenants. I'd be curious to hear your thoughts on a bill we just passed that would require the DNR to provide voter registration applications to those seeking hunting and fishing licenses. My belief is that we should meet people where they are and strive for 100% participation from every eligible voter. Do you agree with that statement?
Yeah, I'm a private practicing lawyer, and that's a legal goal. Do I agree with it? Yeah, I mean, I agree with the end, but the means in which it's used, and that's why I took the Obama case early in my presentation. The concern is the voter registration efforts being demographically targeted. And so Obama argued in that case that you can't target military voters over non-military voters in one. And so targeting, DNR, hunting, fishing applicants over other people should be reviewed. Now, if there's a package, maybe it works. I mean, one way to do it is just to pound every house with voter registration applications, and then you're getting everybody, and that would satisfy that goal of equitable treatment.
Well, we during COVID, every registered voter got an absentee voter application. So you would agree with that?
Yeah, there are no equal protection clause problems there, right? So the Obama lawsuit was saying when you favor a group of people over another group of people, that's questionable. So that, under the Equal Protection Clause, the Sixth Circuit agreed that applies in Michigan. So yeah, I mean, so the ends don't justify the means, and the means need to be reviewed with respect to targeting demographic groups to see if it violates the Equal Protection Clause or not. But yeah, I think I spent my career before judges left and right, and just a common sense approach to law, and the executive officials need to be closely watched. Thank you, sir.
Thank you. I, again, appreciate all of your work, Mr. Kaardal, and your efforts here, and so many great things that you're able to highlight and bring to our attention. I just want to say, for the record, that our governor will call that a special election for the 35th district, as you mentioned earlier. I mean, there's over 220,000 people that are actually unrepresented for that Senate seat. So thank you for your time today. Appreciate it.